call the Honourable Member for Fremantle.
Thank you, Deputy Speaker. And look, through this bill, the government seeks to abolish or dissolve the family court, and that is a massive change to our judicial architecture. It's a change that affects the administration of a particularly important area of law. It's not a change that should be made lightly, particularly when you consider, as the member of Scullin has just pointed out, the very serious concerns that have been raised by expert stakeholders. You can't get more expert than former Chief Justices of the Family Court, the Australian Law Council, the Australian Law Reform Commission, and so on and so on. They've raised very, very serious concerns. So if you're going to come along at the very end of a difficult year and make such a radical change to long-standing judicial architecture in such a critical area, you'd want to do so on a pretty careful and substantial basis. And yet, as we've seen so often this year, bills like this come along that seek to make radical change, and I think in this case to sort of perpetrate a kind of vandalism upon the way things have worked and worked quite well in this country for a long period of time, without any convincing argument being made for that change. And there's no convincing argument in the material. The Attorney-General hasn't been able to advance any convincing argument, and we're not seeing any convincing argument in this place. I'll be prepared to accept a different view if someone in the government wants to point to who exactly on that side of the parliament has come in here and taken stock of the abolition and dissolution of the Family Court of Australia and explained exactly why that's going to occur in the shadow of Christmas 2020. I haven't seen a single member of the government come in and make that argument, and that should be cause for concern. I mean, I don't know what Parliament is for if it's not for us, on behalf of the people we represent in the best interests of Australia, to look closely at these kinds of propositions, to examine them carefully, and in debate flesh out exactly what the basis for making such a radical and far-reaching change is, and whether or not there are any wrinkles or barnacles on what is proposed to be launched. And I don't think you'd have to look too closely at this to see those kinds of barnacles. Australia's society has had the benefit of the family court and its exclusive focus on family law since the reforms of the Whitlam government. All of us will have had some experience of the importance of family law matters, either in our own lives or in the lives of our extended families and close friends, and certainly through our work as representatives. I don't think you could be a representative in this place for more than a month or two before you would hear from someone in your community who is going through a family law matter. They are by their nature very difficult. They stem from the instability and conflict and disagreements that sometimes are part of human relationships, even the closest of human relationships. And so having something supportive in place to allow those conflicts to be considered and resolved, mediated, or dealt with in another way that allows the people in those relationships to move on to something different in a way that is orderly and safe and considerate for men and women, for anyone who's part of a partnership, and particularly for children. You know, it's so important that part of our system, our legal system and our judicial system, is of the highest quality, and yet what's being proposed here is the abolition of what has been a foundation stone institutionally of that area of law. The reforms of the Whitlam government, institutions like the Family Court, have without doubt made a contribution to better dispute resolution in families, to fairer outcomes, I would say especially for women, to less conflict, and in many cases to much safer and healthier outcomes for children. I had reason to go back and look at what Prime Minister Whitlam said in 74, that the essence of the family courts is that they will be helping courts. That's what they're designed to do. And he said, the family court will of course determine legal rights, which it's bound to do as a court, but it will do much more than that. Here will be a court, the expressly stated purpose of which is to provide help, encouragement and counselling to parties with marital problems and to have regard to their human problems, not just their legal rights. Parties will not be driven to the court by their own despair as a last resort. They'll be encouraged to come to the welfare and counselling staff of the court whenever they have a matrimonial problem, even if they're not contemplating proceedings of any kind. And this help would also be available after divorce proceedings, and this would, as I've already indicated, be of great importance where there were young children. And I think that vision of the family court and related family law reforms has been part of Australian life now for 40 years. It was part of my life as a young person. My parents parted ways when I was 5. My brother was 3. My sister was 1. I've had some experience of going through those processes. I know that they're difficult, but I also know that the system we have in Australia, particularly since those reforms, has meant that those processes and that hurt and those kinds of disputes and complicated matters that need to be resolved at least have a framework and a structure through which that can occur, which is much better than the kind of law of the jungle that would prevail otherwise. No one would say that the existing system is perfect. Of course it's not. There isn't any system that's perfect, and there are always ways in which reform can be considered, but you have to focus, you have to ensure that the reform you're thinking about addresses the problems that actually exist. And there's nothing in any of the evidence that suggests abolishing or dissolving the family court will deal with some of the problems that have been identified, like delay. None of the 5 reports listed on the Attorney General's website as informing this bill actually recommend the change that the government is making. When the Joint Select Committee into Family Law provided its interim report, it referred to 70 separate reviews that were germane to the issue of the good function of family law and the family court. Not one of the 70, not one, recommended the abolition or dissolution of the family court and the other changes that are contained in this bill. So, to the extent that there's a need for reform or improvement in relation to things like delay or harmonisation of administrative and procedural matters, great. I mean, get on with it. That's what the Attorney General should have been doing in some of the previous 7 years. But there's nothing in the abolition of the family court itself which will actually address those problems. And as has been the case with this government, in many areas, they bowl along, often at the last minute, doing considerable harm to the way things have worked reasonably well, and certainly better than under their administration, without attending to what clearly are the real problems. And often those real problems have a similar thread or a similar theme. In this case, when it comes to Australian family law, the Australian Law Reform Commission found that the chief problem was that the family law system, and I quote, has been deprived of resources to such an extent that it cannot deliver the quality of justice expected of a country like Australia, and to whose family law system other countries once looked and tried to emulate. So one of the key issues with the way that the system works at the moment is it's been under-resourced, it's been defunded, and that is a defining feature of this government, the art of the self-fulfilling prophecy. Starve an institution of resources, and then if it underperforms, use that as a basis to chop it down, use that as a basis to knock it over. We've seen the same thing in the area of the environment. The government looks at delays when it comes to environmental decision-making, and then sees that as the reason to cut green tape and weaken protections for our environment, when they've cut 40% in funding to the Department of the Environment, and that perfectly coincides with the period in which the delay has increased. So we see the same thing here. The Australian Law Reform Commission makes it plain that the chief problem is under-resourcing of the system as it stands, not any structural or institutional problem, and yet by sort of following that path of ignoring and neglecting, as the member for Scullin pointed out, and neglect, it's another theme of this government, unfortunately, through neglect, that then in turn becomes the basis for doing further radical harm. And I remember actually back in my local government days that you'd occasionally have people that would have a building with some sort of heritage quality that they wanted to demolish altogether. And we would tell them, that the council, I think quite rightly, would say, well, no, you know, this has got significant community heritage, and you own the property. In that sense, you're a kind of a custodian of that heritage going forward, and you need to look after it. And so what they would bloody-mindedly do in some cases is they would just leave the property to get worse and worse over time. If in some cases they seem to partially redo the roof so that there was a fair bit of rain coming in and various other things, and that, yeah, demolition by neglect, exactly, demolition by neglect. And that's one of the ways in which this government sadly has worked, rather than actually focusing on systemic issues that can be improved, can improve delays in the family law system and through the family court. Reviews have identified ways in which that can occur through the timely provision of relevant reports, again through proper resourcing, through the timely appointment of judicial officers. Those are how you address problems of delay. Those are how you improve administrative procedural consistency. Coming along and saying, guess what, it's worked very well for 40 years, but we're going to abolish the family court, when not a single member of the government will come in here and make that argument is really astonishing. Well, I don't know that. I'm told that there have been a few, but there must have been very, very, very few. When you don't have the member for Fisher, there you go. So there was one. Sorry. Okay. So I'll tell you, there's apparently been one, and there could have been more. We're going to abolish the family court. We're going to abolish the Family Court of Australia. We're going to abolish the Family Court of Australia, and the government has managed to turn out one or possibly two members to make that argument. So there's been no reports. The government on the Attorney General's website, there are no reports that make this recommendation. Of the 70 reviews in the Joint Standing Committee's interim report, the Joint Select Committee, I should say, into family law, no reference or recommendation of this. Two government speakers have come in and made the argument. Is there any opposition? There is, yes, there is a bit of opposition. I mean, I've already talked about the Australian Law Reform Commission. I've already talked about previous heads of the family court. No less than 110 stakeholders actually made submissions in opposition to what's being proposed. As the member for Scullin said, the second Chief Justice of the Family Court said, "It is unbelievable that government would propose the dissolution of a federal superior court in this fashion without the most careful and searching public inquiry. It is unbelievable." The Law Council of Australia said, "The proposed merger is a terrible gamble with the lives of children and families." Community Legal Centres Australia said, "Moving away from a specialist family court model would be a retrograde step and expose survivors of family violence to unnecessary risk." These are not trifling matters, Deputy Speaker. These go to the very core of a government's responsibility to keep people safe. I don't know if we ever get told anything more vehemently than by those on the government side than the number one priority and the number one responsibility of government is to keep people safe. This is a change that the Law Council Australia describes as a terrible gamble with the lives of children and families. The National Aboriginal and Torres Strait Islander Legal Service has said it will disproportionately impact the most vulnerable, including Aboriginal and Torres Strait Islander children. That is what the government is proposing to do without any basis, not connected to any of the existing problems that they might get on with and address, not with the foundation of any evidence or any decent analysis, in the shadow of a Christmas, with one or two people who are prepared to come up and say something good about it, it is not the way to make radical, harmful change to Australia's family law system.